has been on the Legal NORML Committee for a long time. He helped draft Proposition 215, and he has been a really solid, one of the best known medical marijuana defense attorneys and marijuana defense attorneys in the state. And so we're all looking forward to hearing what Bill Panzer has to say. Please join me.
Thank you, Chris. It's been a while since I've been at this. About 16, 17 years ago, Dennis Perone asked me to take a crack at drafting what became the Vasconcellos bill, which then morphed into Prop 215. And I just want to share my observations, what I believe, and something that should be considered in drafting any potential new initiative for 2012. One, I've come to the conclusion that maybe 1% of the electorate actually reads the initiative. Maybe 20 or 25% read the summaries that are in the voter pamphlet. The other 70 or 75% get it all from the internet, TV, newspapers, what's left of them, and basically the gestalt. I'm for marijuana, I'm against marijuana. What does this mean? It means my belief is that we need, whatever we decide is going to be in this initiative, the drafting needs to be for the purpose of implementation, not for the purpose of passing it. Regardless of what's in it, it's going to pass. Now, for example, there's two things. There's what should be in it, what do you want the initiative to do, and there's what language do you actually put down on that piece of paper to accomplish it? Now that's like another language. It's kind of like it has to be in Chinese. Well, if you want to interpret it into Chinese, you need to get a Chinese interpreter to do it. Now I want to give you an example. How many people here think that Prop 19 potentially created a threat to medical patient rights? How many people here think that the drafters of 19 wanted it to create a threat to medical rights? A lot less. Personally, I did not like 19. I thought the drafting sucked. I don't think that Richard intended to impinge on medical rights. I don't think Richard wanted, well, please. I don't think that Richard wanted to give Los Angeles the right to cut off medical rights. However, the drafting of it left that argument open. Now, Chris disagrees with me. Some people disagree with me as to whether or not it would have done that. But the problem is the argument is there. The language was not bulletproof. It allowed the argument to be there. SB 420. I predict that before the end of this year, we're going to get a Court of Appeals decision that's going to say that most dispensaries in the state are not legal under state law. And the problem is in the words the drafting. 11362.775 says that patients and caregivers may associate collectively or cooperatively to cultivate for medical purposes, and based solely on that fact are not guilty of sales, transportation, blah, 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 blah. Now, I have no doubt that the people drafting SB 420 intended it to allow for collectives, intended to allow for cooperatives and dispensaries. The problem is that language. Shall not solely on the basis of that fact, they're not guilty of sales. Well, what happens is a court can look at that and go, okay, here's what the DAs are arguing. Solely based on the fact that you're cultivating, you're not guilty of sales. But if you take what you cultivate, you put it in a counter, and you sell it, those are new facts. Those are different facts. Those are the facts that make you guilty of sales. We've had trial courts in Los Angeles accept that argument. And I expect that that's going to filter up to the Court of Appeals, and we're going to get a decision sometime this year that's going to very much impinge on the ability of dispensaries to operate. Now, thankfully, they're entrenched enough, and there are enough cities around that are making money off of this, that I think there's going to be a rush up the freeway to Sacramento with Oakland, Berkeley, San Francisco, San Jose. The ones who are like, they've got the teeth. They like the money. They don't want to see that teeth cut off. They're going to be going to Sacramento and putting pressure. We need the legislature to come forward with some type of distribution legislation. But regardless, if I can leave you with one thing to consider today, it's this. Whatever everyone agrees that this initiative should take, whether it's full legalization, decrim, whatever it is, the wording should be run through us, the people on this panel, the criminal defense lawyers that know how to speak the language, the people who are in court every day dealing with the DAs, the cops, the trial judges, the appellate court judges. We know how they think because we go up there and we're fighting the language that's in 215, the language that's in SB 420. Let's not make the same mistake again. Everybody wants a piece of the pie, but let us at least make sure that the language actually gives you the piece that you want. Thank you.